California's fictitious Doe defendant practice. California's unique Doe defendant practice is significantly more liberal than that recognized in other jurisdictions and in federal practice. See James E. Hogan, California's unique Doe defendant practice, a fictitious stranger than truth. Stanford Law Review, 1977. California allows plaintiffs to name as Doe defendant parties whom the plaintiff has no reason to believe even exists solely as insurance against the statute of limitations bar. Designed to mitigate the harsh effects of California's Doe defendant practice, permits relation back to the date of the original pleading in a broad variety of circumstances unknown to the federal courts under Rule 15c3 FRCP. Ordinarily, relation back is allowed by the simple expedient of substituting the new defendant for one of the Does. California's Doe defendant practice has evolved through case law interpreting three rather innocent-looking statutes, Section 474, 350, and 583.210 of the California Code of Civil Procedure. These statutes have existed in some form or other since the original Practice Act of 1851. Section 474 is legislative centerpiece of the fictitious defendant practice, providing part and part. When the plaintiff is ignorant of the name of the defendant, he must state that fact in the complaint, and such defendant may be designated in any pleading or proceeding by any name, and when his true name is discovered, the pleading or proceeding must be amended accordingly. As will be discussed in Stryker v. Tommy's Electric Company, reproduced infra, the California courts have constructed CCP 474 to include a relation back concept. That case is on the next page and was heard by Justice Pinelli, or opinion written by Justice Pinelli, 1985, the 6th Appellate District Court of Appeal of California. Plaintiff appeals from a judgment of dismissal entered after defendant's demur to an amended complaint was sustained without leave to amend on the ground the statute of limitations barred the action. We reverse. The facts are on October 4th, 1979, plaintiff Frank Strycher filed a complaint for personal injury sustained on July 16, 1979 at a construction site when certain radio-controlled overhead garage doors opened, causing him to fall from the scaffolding upon which he was working. The complaint named as defendants Shippers Development Company, general contractor, Salinas Steel Builders, Inc., subcontractor, Jack's Overhead Door Company, Inc., and John Hendricks, independent contractors and installers of the electric doors, as well as 4 fictitious business entities, Black, White, Blue, and Gray companies. These fictitious individuals comprising Gray Company as a partnership, Does 1, 2, and 3, and 97 additional fictitious defendants, Does 4 through 100. The first paragraph of the complaint alleged that the true names and capacities of the fictitious defendants were unknown to plaintiff, but stated that these were ascertained. Plaintiff would move to amend the complaint accordingly. Paragraph 6 alleged a cause of action for negligence, charging the defendants own, possess, and control the construction site, that they had provided an unsafe workplace through their failure, among other things, to supervise and control the installation and operation of radio-controlled overhead garage doors on the work site, and that such negligence resulted in plaintiff's injuries. On May 18th, 1982, 2 years and 10 months after the accident, and after settlement was obtained with the named defendants, Strycher first filed a first amended complaint against respondents Tommy's Electric Company and Shima American Corporation in Does 4 through 100. It alleged respondents designed, manufactured, marketed, and sold the radio-controlled overhead door openers involved in the accident, and that these openers had been defectively designed and would malfunction without human intervention. The amended complaint stated cause of action for negligence, breach of express and implied warranty, and strict products liability. On June 17, 1982, Respondents demurred to the first amended complaint on the ground that the claim was barred by the 1-year statute of limitations in Code of Civil Procedure Section 340, Subdivision 3. Respondents also moved the court to judicially notice pursuant to Evidence Code Sections 452 and 453, all the pleadings and records in its file on the case, including cross-complaint filed by Jack's Overhead Doors, one of the named defendants, in a complaint in intervention filed by Industrial Indemnity Co., plaintiff's employers workers' compensation carrier, both filed in February of 1980, which included respondents among the named defendants and alleged causes of action for indemnity based on a product's liability theory. Respondents argued in their moving papers that since plaintiff's amended complaint did not substitute respondents for any of the fictitiously named defendants in his original complaint, the amended complaint was in fact adding new defendants to the action, and that this was not permissible after the running of the 1-year statute of limitations. Respondents further argued that even if plaintiff's defective substitution of fictitious defendants was cured, the provisions of Code of Civil Procedure Section 474 allowing the amendment to relate back to the filing of the original complaint did not apply because in February of 1980, plaintiff had notice of respondent's identity through the filing of the cross-complaint and intervention pleadings, yet he had nevertheless failed to exercise due diligence in amending his complaint before the expiration of the statute of limitations in July of 1980. Stryker opposed respondent's demur and moved for leave to amend his complaint in order to properly substitute respondents for specifically named fictitious defendants, arguing his failure to do so constituted a procedural error which could be easily cured. Stryker also argued the benefits by Section 474 would apply because he was not aware of any facts constituting the basis for a product's liability cause of action against respondents until March 30, 1982, when an electronics expert indicated that the electric door controllers involved in the accident were defective. The court sustained respondents' demur without leave to amend on the ground that statute of limitations barred the action. The court's minute order also noted that plaintiff's early pleadings were consistent with his belief that before March 30, 1982, he had no basis for an action against the two defendants. This appeal followed. Discussion. On appeal, Stryker contends the trial court erroneously sustained the demur and abused its discretion in denying him leave to amend the complaint to cure his failure to specifically substitute respondents for fictitious defendants named in the original complaint. We find these contentions meritorious. Discussion. On appeal, Stryker contends the trial court erroneously sustained the demur and abused its discretion in denying him leave to amend the complaint to cure his failure to specifically substitute respondents for fictitious defendants named in the original complaint. We find these contentions meritorious. Got it. Preliminarily, we must determine whether Stryker's first amended complaint, absent his defective substitution of respondents for the fictitiously named defendants, relates back to the filing date of the original complaint under Section 474, thus defeating the bar of the statute of limitations. The purpose of Section 474 is to enable a plaintiff who is ignorant of the identity of the defendant to file his complaint before his claim is barred by the statute of limitations. There is a strong policy in favor of litigating cases on their merits, and the California courts have been very liberal in permitting the amendment of pleadings to bring in a defendant previously sued by a fictitious name. Citing Burroughs v. American Motors Corp. 1983, California, which also cites Austin v. Massachusetts Bonding and Insurance Company, a California case. And see also Motor City Sales v. Superior Court in 1973. It is also well settled that the amended complaint will relate back to the date of filing the original complaint, provided it seeks recovery of the same general set of facts alleged in the original complaint. That's from Austin v. Massachusetts, 1974. Melfley v. Nicholson Manufacturing Company, Barrows v. American Motors, Moreover, it is clear that where the original complaint contains standard Doe allegations alleging negligent theories, it is proper to amend the complaint to bring in other defendants on warranty and products liability. Since the amendment involves the same accident and injury, the amendment relates back to satisfy the statute of limitations. We get that from Barrows versus American Motors, and also a new one, Garrett versus Crown Coach Corp, 1968. However, in order to claim the benefits of Section 474, a plaintiff's ignorance of defendant's true name must be genuine and not feigned. From Stevens v. Berry, 1967, and Schroeder v. Lowers, 1968. We must therefore look to see whether plaintiff knew the defendant's true name at the time he filed his original complaint. Plaintiff's requisite ignorance of defendant's name under Section 474 has been expansively interpreted by the courts to encompass situations where he knew the identity of the person but was ignorant of the facts giving him a cause of action against the person, citations omitted, or knew the name of all the facts but was unaware of the law gave him a cause of action against the fictitiously named defendant, and discovered that right by reason of decisions rendered after the commencement of the action. Citations omitted from Marasco v. Wadsworth, 1978, quoting with approval Barnes v. Wilson, Supra. Moreover, Section 474's ignorance requirement, quote, is restricted to the knowledge of the plaintiff at the time filing the complaint. From Munoz v. Purdy, 1979, italics added, Michalo v. Horwald, 1964, and does not relate to steps that should be taken after the filing of the action. Guided by the foregoing principles, we turn to the case at bar. Stryker's original complaint contained standard Doe allegations against fictitious defendants and unknown as required by Section 474. Although the original complaint alleged a cause of action for negligence against all defendants for failing to provide a safe place to work, it was proper to amend the complaint to bring in the defectively substituted defendants on the additional warranty and products liability theories of recovery, since the amendment involved the same accident injury alleged in the original complaint. See Smeltley v. Nicholson Manufacturing Co. It is undisputed that at the time Stryker's original complaint was filed, he was ignorant of respondents' identity or of their participation in designing, manufacturing, or selling the electronic door openers involved in the accident. Likewise, Stryker did not know at this time any facts which would indicate the possibility of the door openers were defectively designed, as such flaw in design was not externally visible. Respondents contend, nevertheless, that Stryker did not, in good faith, avail himself of the provisions of Section 474 because 4 months after his original complaint was filed, he was alerted through the filing of cross-complaint and intervention pleadings of respondents' role in manufacturing and distributing the electronic door devices, and of the possibility they could be sued under a product liability theory of recovery. As pointed out above, the plaintiff's actual knowledge at the time the suit was filed is dispositive in triggering the application of Section 474's fictitious defendant provisions. From Michalo v. Horwald, Munoz v. Purdy. Further, it remains disputed that at the time of filing the original complaint, Stryker was ignorant of respondents' identity or of their status as manufacturers and distributors of the defective door openers. Moreover, there is no requirement under the Section 474 that plaintiff exercise reasonable diligence in discovering either the true identity of fictitious defendants or the facts giving him a cause of action against such persons after the filing of a complaint and up to the expiration of the applicable limitation period. Munoz v. Purdy, Barrows v. American Motors. As aptly stated by the court in Munoz Supra, the interjection of a discovery standard into Section 474 would lead to the harmful practice in all litigation of requiring that all persons who might conceivably have some connection with the lawsuit be specifically named in order to avoid the sanctions of the failure to comply with the inquiry requirements of Section 474. Respondent also argues that, irrespective of appellant's lack of knowledge of the true identity of the fictitiously named defendants at the time he filed the original complaint, he was nonetheless dilatory in filing the amended complaint once he acquired knowledge of the true identity of those defendants fictitiously named. Respondent contends that unreasonable delay in filing the amendment after actual discovery of the true identity of the fictitiously named defendant can bar a plaintiff's resort to the fictitious name procedure. Some authority for this proposition can be found in Barrows v. American Motor Corps, and Barnes v. Wilson, Supra. Here, however, the trial court was only dealing with the demur and the amended complaint. Defendant's demur, however, tests only the sufficiency of the pleadings. Nothing in the pleadings suggests that plaintiff, after learning of his cause of action against defendant, was dilatory in amending his complaint, or that defendant suffered prejudice from the delay. Citation. From such delay. Smelty v. Nicholson Manufacturing, omitted. Citation omitted. Nothing in this record suggests appellant was dilatory in amending his complaint. In fact, the trial court's order states that before March 30, 1982, quote, appellant had no basis for action against the two defendants. Once he learned the facts giving him a cause of action against respondents on March 30, 1982, his first amended complaint naming respondents as defendants was promptly filed on May 18, 1982, within 2 months of discovery. We conclude that after Stryker's defective substitution of respondents for the fictitiously named defendants, the first amended complaint relates back to the filing date of the original complaint under Section 474, thus defeating the bar of the statute of limitations. The issue remains whether the court abuses discretion in denying Stryker leave to amend the complaint to cure his failure to properly allege that respondents were being substituted for some of the fictitiously named defendants in the original complaint. Stryker argues the omission constituted a procedural error which was easily curable through amendment. We agree. It is axiomatic that if there is a reasonable possibility that a defect in the complaint can be cured by amendment, or that the pleading liberally construed can state a cause of action, a demur should not be sustained. We are satisfied that amended complaints allegations sufficiently state a cause of action for product liability against respondents. Moreover, an amendment substituting the true names of fictitious defendants is not a matter of substance because it does not change the cause of action or affect the issues raised in the pleadings. From Vincent v. Grayson, 1973, since the defect in the complaint does not affect the substance of its allegations and it is reasonably possible the defect can be cured by amendment, we conclude the trial court abuses discretion in dismissing the action without giving Stryker the opportunity to amend. The judgment of dismissal is reversed. There's a significant number of case notes after this case. I'm going to read them by title and come back. 1. Requirements for use of Doe defendant practice. 2. Ignorance of defendant's name. 2A. Ignorance of defendant's actual name. 2B. Ignorance of facts giving rise to the cause of action. 2C. Ignorance that the law provides a cause of action. Note number 3, the requirement of actual ignorance. 3A, in Irving v. Carpentier. 3B, in Wallace v. Southern Pacific Transportation. 3C, Parker v. Robert Key. 3D, what if the plaintiff's ignorance is due to his or her own negligence, in Ballon v. Drost. 4, Doe defendant practice and the delayed discovery rule. 5, time limits for service of amended complaint. 6, Federal Rule 15C3 compared. And 7, Federal Court application. Before moving into Subpart C of Chapter 3, demurs, which we'll record at another time.